I have decided not to recuse myself. I repeat, I have decided not to recuse myself.
I reject the idea that I am a member of a member and or that I am unable to think independently and impartially on this or any other matter.
This was in October last year when the recusal application against the chairperson and a DA MP was dismissed. The suspended public protector is now challenging the dismissal of the recusal application, as she warned last year.
There's a possibility that the non-recusal might cause the starting of the proceedings afresh of this committee. Then it would obviously be foolhardy to wait for the outcome and then start again in 2023.
Mkhwebane is also challenging the committee's decision not to call Ramaphosa as a witness after that request was also dismissed.
Each of the subpoena based on irrelevance for the president, we're not going to go that route. We're not doing it.
We will then take your letter at face value as the final word on the issue, and then we will take whatever legal steps might be necessary to secure the presence of this necessary witness.
The committee heard last week that Mkhwebane wants the High Court to force Ramaphosa to appear as a witness.
There also seems to be an ongoing request that the committee reconsider its decision to summons President Ramaphosa. So, Chair, these matters in fact form part of the current review process before the Western Cape High Court, and that matter is due to be heard on the 7th and 8th of February.
In the inquiry this week, there was a debate on summoning former public protector, Professor Thuli Madonsela. Madonsela responded to Mkhwebane's legal team, indicating that she is not keen to appear. In her communication, she states she does not see the rationale for her appearance. Madonsela argued that all information sought from her was with the Public Protector's Office. She says for any investigations-related matters, Mkhwebane must rely on observations and findings of the courts. This in regard to the South African Reserve Bank and Vrede Dairy Farm matters.
What the committee could do, however, is to provide all the records that it does have available to it. They have all been uploaded in an electronic format, and some assistance could at least be given to narrow down those documents into specific areas that the committee seeks the testimony of the former PP on.
The committee says it will now subpoena Madonsela.
We want to reaffirm our decision to have Professor Madonsela come to the committee.
Former Deputy Public Protector, Advocate Kevin Malunga, has agreed to voluntarily assist the committee. And in another development, Mkhwebane has also complained that her legal team has not been paid by the Office of the Public Protector.
This issue will definitely impact on the committee if the Public Protector does not have her legal team. We thought it fit that we at least alert the CEO and that we ask for an update as to what is causing the delay.
Mkhwebane has called 4 witnesses so far, while the evidence leaders have called 18. Mkhwebane's third witness was the Zambian public protector, who was quizzed on whether it was wise for a public protector to make recommendations on constitutional amendments. One of the 4 charges facing Mkhwebane is misconduct. It relates to her recommendation to change the mandate of the South African Reserve Bank. The accusation is that she failed to give affected parties time to comment on her recommendation. That resulted in the economy losing 1.3 billion rand in government bonds.
In circumstances where the Reserve Bank had specifically asked for an opportunity to look at the report to ensure that there wasn't harm to the economy. That was not adhered to and the report was not provided to the Reserve Bank. This resulted in a significant depreciation in the rand and the sale of by non-resident investors of 1.3 billion rand worth of South African government bonds.
I'd say that in some jurisdictions, especially in Europe, the ombudspersons do make recommendations for the changes of laws. I think you saw it under the Venice Principles.
That's correct.
So it was in that regard that I answered in the affirmative.
Mkhwebane's legal counsel, however, moved to dispel the argument that the public protector cannot make recommendations of constitutional amendments.
If the public protector felt that there was something that is detrimental to the public, which is in the Constitution, advertently or inadvertently, is there anything wrong with suggesting that that should be attended to by Parliament, obviously using its own procedures?
The public protector may make a recommendation if either a rule or regulation, a law, in some way it causes maladministration. The public protector may make a recommendation. It is a recommendation which the legislature, once the report is tabled, the legislature can decide either to interact with the executive to find out whether it's possible or not, or if they want, they can reject the report. The legislature has got the right to reject the report.
Another charge that Mkhwebane faces is intimidation and harassment of staff. One of the staff is regional manager Phelo Samuel, who was dismissed in 2020 and later reinstated by the CCMA. The dismissal of Samuel has two versions, depend on where you stand. Samuel argues that he was dismissed after a complaint to Parliament that Mkhwebane was diverting funds from core business to fund reckless litigation to defend her reports. But according to Mkhwebane, Samuel was dismissed after his 2017 conviction and sentence for assaulting a complainant in the office of the public protector in 2011. According to Mkhwebane, Samuel has since appealed.
Mr. Samuel's entire version to this committee was that the public protector firstly was trying to get rid of him because he was a whistleblower. Secondly, he could not understand why the public protector would, under the sun, want to take disciplinary action against him when she became aware of this assault.
That is Samuel. He's going to do everything. He's going to do everything for advocate.
He will do whatever it takes so that to do away with Ms. Mkhwebane. That is the whole gist of the matter here.
After all the witnesses have been called, the committee will be seized to decide which evidence is relevant to the charges that Mkhwebane faces. Mpofu has sought to portray the witnesses of the evidence leaders as liars, disgruntled employees, as well as irrelevant. On the other hand, the evidence leader has portrayed Mkhwebane's witnesses as being unaware of the basis of the charges and their evidence irrelevant. Mkhwebane is yet to give evidence. The Section 194 inquiry is set to resume on the 13th of February. Ulelani Philip, SABC News, Parliament.